Greetings from Arusha, Tanzania. My name is Sunday Ndamgoba. I will be your moderator today. With me is Catherine Kariuki from Triple OK Advocates, Kenya. Today we have a very good and able panel with us. We'll be discussing the commercialization of intellectual property rights for business in East Africa, looking at IP as a business asset. We on the list of our speakers today, we will have Dr. Tony Kakoza, who is a partner at Bianca Kihika and Company Advocates in Uganda. Then we have Rosemary Kimwatu, I hope I pronounced it right, who is the head of data protection at KCB Group, Kenya. Then we have Arthur Rugango, who is a partner at SEDA, ACLO, Rwanda. And we have Mkama Magoti Kalebu, who is the managing partner of Endo and Company Advocates from Tanzania. And we also have Leila Nyagahene, who is an associate with DLA Piper Africa from Burundi. In today's session, we plan to have at least 2 minutes for each panelist to introduce themselves briefly. And thereafter, we'll jump into at least one presentation, and then we can do a line of questions, of which my co-moderator, Catherine, will talk over. And after that, we'll open it to the floor. So I welcome you all to this session, of which I believe it's pivotal. The practice is different across our region, East Africa, but I believe it's one of those topics that were long overdue. Commercialization of assets, of IP as assets. We are talking of the East African community. We are talking of the Africa Free Quoted Area, movements of goods and services, the IPR protocol. All these things come in line with the importance of having IP as an asset. IP evaluation, IP laws of which now would cater to having companies being able to go to banks and take loan, have collaterals and the such. So in fact, I'm very excited about this, and I'm looking forward to learning from other jurisdictions. So to kickstart, I will let my co-moderator also introduce herself, and then I will allow for the rest to come in. Oh, Catherine, let's do this. Let me just let everyone introduce themselves. And then once that's done, then you jump on board and introduce yourself as the last one. And then you can do the question. So I will start with the doctor. If you can introduce yourself, and then you move to Rosemary, Arthur, Mkama, and Leila in that order. Thank you, doctor. The floor is yours, please.
Thank you very much, Sandy. It's always a pleasure to share experiences and expertise with the East African Law Society. So thank you, Sandy and Catherine, for always extending this opportunity. Good afternoon, colleagues. My name is Anthony Kakoza. I am a partner in the law firm of Bianca Kihika and Company Advocates, which is a commercial litigation and corporate law firm here in Uganda. I head the intellectual property department of that firm. I also engage in academia. I teach intellectual property both here in Uganda and in a number of other universities across the globe. Within the legal practice sector, I head the intellectual property cluster of the Uganda Law Society, and I've also continued to do consultancies for the Africa Regional Intellectual Property Organization and the World Intellectual Property Organization in various divisions of intellectual property. So thank you.
Thank you very much. Rosemary, if you can jump on.
Thank you very much. I'm Rosemary Kimwatu, and I head data protection for KCB Group, and I'm happy to be here. I'm an advocate of the High Court of Kenya, a member of the Legal Hackers, which is a global group of technologists and lawyers who come together to discuss emerging policy issues. And looking forward to great conversations today with this esteemed panel and sharing insights in what we've seen in the IP practice in this market. Thank you very much.
Thank you very much. Over to you, Arthur. Maybe we can have Arthur on a bit later, so I'll skip that and invite Mkama. Please introduce yourself, and then Arthur will be last as soon as he joins us. Mkama, I think you're either muted.
Oh, okay. Thank you. Can you hear me now?
Please go ahead. Yeah.
Okay, thank you. Hi, everybody again. My name is Mkama Boti Kalebu. I am a managing partner at Indian Company Advocates. I also head of intellectual property department at Indian Company Advocates, a law firm based here in Dar es Salaam, Tanzania. I am also an advocate of the High Court of Tanzania and the subordinate court here too. Also advocate of the High Court of Zanzibar and the subordinate court here too, same for Kavi's Court. I am also a member of East African Law Society Intellectual Property Committee. As you all know, today we'll be discussing on commercialization of intellectual property, right, business, IP as a business asset. In my side, apart from taking or discussing on the general questions, I will be presenting on the aspect of commercialization of intellectual property in Tanzania. So I welcome you all. Let us go together. Thank you, Sandra.
Great, thank you very much. Leila, please, if you could introduce yourself. Leila, are you able to hear us? Perhaps if you could unmute.
Yes, thank you very much. I will start by thanking ELS for inviting me to be one of the speakers. I'm Leila Nyagareli from Burundi, associated to Rare and Advocate, member of Daily Pipe Africa, and I'm working in the IPT sector. Thank you.
Thank you. I believe Arthur has not joined us yet, but as soon as he does, he will introduce himself, and we can take it from there. So the panelists are always last to introduce themselves. So my name, as said earlier, is Sunday Namgobra. I'm the managing counsel of ABC Attorneys. We are based in Tanzania. We have offices in Dodoma, in Tanzania, Dar es Salaam, Arusha, and we practice in Zanzibar as well. I head the IP cluster, so I'm the chairperson of the IP committee and the East Africa Law Society. My co-moderator is Catherine, who will also introduce herself, and then I will leave it to her to take it from there. So Catherine, if you could, please introduce yourself, and we kickstart our webinar.
Thank you very much, Sante. Good day, everybody, and welcome to today's webinar. I think it's safe to say we are all excited at the prospect of what we're going to discuss today. A very exciting topic, very timely. So many emerging issues happening in the IP space. As Sante said, my name is Catherine Kariuki Mulika, and I am an advocate of the High Court of Kenya. I practice from Nairobi, Kenya, and I practice as Triple OK Law Advocates, which is a law firm based in Nairobi. We're a member of Meritus Law Firms. I also am a partner in the TMT department, which houses the IP practice at Triple OK Law Advocates. And So we'll just dive right in. I also deputize Sunday at the IP committee. I'm also a member of the IP committee at the ELS. And we'll just dive right in. And I think the best person to start the conversation and lay the foundation for us, him being a teacher, lecturer, and practitioner, is Dr. Kakuza. So Dr. Kakuza, I'm going to throw the first question to you for you to just lay the foundation for us. For those of us who've come and we are a bit green, we're not seasoned practitioners in the area of IP. Just if you can lay the foundation for us when we say IP, looking at IP as an asset and being able to commercialize it. If you can lay the foundation for us, what that basically means generally, and then proceed to also tell us as an expert in IP rights, then how can businesses in this day and age effectively identify and protect their IP assets, and also not only protecting, but also proceeding to commercialize it and or maximize the commercial value of the IP assets that they possess. Over to you, Dr. Kakuza.
Okay, thank you very much, Catherine. What is IP? IP is intellectual property, it's creativity of the mind. And every business that is out there to make money, of course, every business is out there to make money, has intellectual property, but many of them do not think about this. So when we talk about commercializing your intellectual property, it's trying to squeeze out every little ounce of value that you can out of that creativity of the mind that is within your business. And this is, of course, something that involves carrying out an audit. So try and imagine someone who is running any kind of business, let's say selling clothes. That person may want to audit how the capital, which is the clothes that he or she is selling, are going. How many have I sold per week? So you do a stock taking and the like. So let's try and move away from looking at the actual physical clothing that this person has and look at the intellectual property as the stock. And that's how you do the audit. So when we talk about commercializing of intellectual property, I can only sum it down to 2 or 3 words: intellectual property audit. You have to carry out an audit of the intellectual property that you have in your business to start seeing how to commercialize it. You may even have already been commercializing it without knowing. So the first step in the audit process is to identify the readily identifiable intellectual property that you have. And the assets falling in this category will include any registered trademarks. So of course, when you have a business, you will want to brand that business with any logo or any marks or any signs or colors or smells that go with it. And the stretching that trademarking goes into what is called branding. So the registered trademarks that go with it, what are the copyrights that go with your business, designs or any patents which are owned by your business. You have to list all of these. And then you look into the licenses that you have done with third parties. Have you allowed other people to use your intellectual property? You still own it, but you're allowing them to capitalize it maybe in another branch office or in another country, or you have a franchise arrangement. So that's where the licensing comes in, or when you're licensing to third parties, including cross-licensing, where it's a quid pro quo. They allow you to use some of their intellectual property and you in turn allow them to use yours. We've seen Samsung and Apple doing this with their phones. They cross-license their technology. So also included in this category are things such as in-house work manuals, databases. If it's a restaurant, what are the recipes that you have? We have, for instance, the Yum Brands, which is known as the second biggest restaurant or food chain company in the world after Coca-Cola. Yum Brands owns KFC, it owns Pizza Hut, it owns Taco Bell, and it's in over 100 countries. So they have recipes which are protected through trade secrets, and that is intellectual property. And they allow people in various countries to run these restaurants through franchise agreements. When you have publications in place and product write-ups or process know-hows, all these things have been written down, so you've sought copyright protection for them. So all this goes into the IP audit that we're talking about. And once you've identified the intellectual properties, then scrutinizing to determine who owns them Is it really the company that you're running, or is it individuals under that company? I may be a director in a company and I come up with an idea for something, but I'm smart enough to register it as my own and not for the company which I work for. So the ownership should not be taken for granted when you're discussing auditing of companies for the commercial sake of it. And you look into issues such as where are the external market influences. These can include the company brand, the product brands, the get up, the goodwill, product certification. Do you have to go through a National Bureau of Standards to give you certification to run your business? If you're running a petrol station, you have a brand that goes with a trademark that goes with it, but have you sought certification from the standards authority of your country to allow you to deal in that business? So this is also part of the commercialization. You also need export certifications if you're going to be exporting your intellectual property outside of your boundaries. And you need, of course, regulatory approvals to go with it, as well as distribution and raw material networks, client lists. For instance, if your business relates so much with outsiders, with clients, tour and travel companies, distribution companies, all these rely a lot on client lists. And we've seen litigation that holds that client lists are actually trade secrets. So that is also intellectual property. And then you also think about marketing and advertising programs. So when you're advertising, you may want to control how your products are advertised. For instance, we have some of the milk industry companies here in Uganda that have a stronghold as to how their adverts are run. So if they're controlling this and they're directing it, then the copyright is theirs. Or if they hire someone to help with the advertising programs, both visual and audio, who really owns the copyright behind the adverts. So all this has to really go into the intellectual property audit. And once you've put it all out, and then you would start thinking about what the commercial element in your company is based on that audit, it can allow you to actually understand the full value of your company, both the tangible assets as well as the intangible assets, which are your intellectual property. I don't know if it's the same in many of the other East African member states, but in Uganda, and I believe also Kenya, we have legislations on using intellectual property as collateral. So you can actually present your IP assets for your company or as an individual and use them as security for a loan, as long as you can prove that you own the IP. So this has to be presented through a certificate if it's those registrable types of IP like patents and industrial designs or trademarks. And if you have an audit report, which is difficult to obtain but possible through audit firms, if you have an audit report that shows how much your particular intellectual property brings in. So that also takes us into a really long lecture, which I won't give at this point, as to what do we really mean by IP value. Because you have to value your IP in order to know that you're making money out of it. And part of understanding the IP value chain goes to the IP audit that I've already talked about. But another part of it would be probably answering the question that what would you lose if someone stole your IP asset from your company? Here you would be looking at what was the income generated out of the IP, or what was the cost involved in creating or generating this IP, or what is the market value depending on competitors in this field. So in a nutshell, that really answers the question, Catherine. Thank you.
Oh, thank you for that. Thank you very much for that, Dr. Kakuza. Thank you for laying the foundation of what IP is and how, when we think of IP and the value of IP, what we would be looking at. So maybe I would now jump to Rosemary. And Dr. Kakuza, be on standby. We'll ask you more questions to follow up with the introduction that you've just given us. Maybe we should jump to Rosemary. And Rosemary, in this day and age, I'm glad that you're here and you're in the area of data protection, because at some point within the webinar, I want you to paint a picture of us of what is a point of convergence between the traditional definition of IP, the way we looked at it, and then there's now data. People look at data as an asset, and hopefully you can be able to draw that convergence for us. Now we see companies that, huge Fortune 500 companies that can really be said to stand on IP as their main asset, or as sometimes their only asset. So maybe what we can start with is maybe you can paint a picture for us as you being an in-house counsel and being a practitioner in the fintech space. Maybe in your experience, what are the common challenges that you'd say are faced by businesses in East Africa when it comes to commercializing their IP rights, and how can these challenges be overcome? But even before you paint the picture of the challenges, it would be nice if you can paint a picture to us of how, picking from where Dr. Kuza left, how are companies leveraging on IP as an asset in this day and age, and therefore then what are the challenges they experience, and what can be done to mitigate or address these challenges? Over to you, Rosemary.
Thanks, Catherine, for the very long question, but yes, I'll try cover it piece by piece. I think the biggest challenges that companies face, especially in East Africa, IP is something that is very intangible. So in your scheme of things, I think many times you're trying to keep the lights on. You're trying to get your next round of investment. You're trying to get your product working. You're trying to get more people to consume. And sadly, sometimes intellectual property handling, management, audit, as has been mentioned, goes on the back seat in terms of the specific things that are required. Yet as businesses grow, as you get more information, as you grow your client list, as you develop your products much better, it gets to a realization where you realize that, look, I have to sit down and actually put my house in order and see what value have I created. And of course, intellectual property is a good measure of this. And of course, linking up with the data conversation is we're always generating information, we're always generating data, but many times we don't have proper governance measures for the kind of data that we create, and which then hampers our ability to adequately monetize that data that we have and maybe use it for other things within the business. So first and foremost, a key challenge is awareness. You're trying to keep the lights on, you're trying to make things to keep working. So only a few SMEs, speaking now on the fintech space, have adequate knowledge on IP. Two, the second thing is even seeking help for IP protection, engaging a legal counsel. Like, will you pay for your licensing fees? Your annual licensing, will you pay your taxes, or will you pay an IP lawyer? However, the more, and actually it's a problem, but a solution is also needed, that the more you realize that that is something of value to your business, then I think investments should be made in trying to analyze, record, and then now register. And connected to that, of course, is budget constraints. That happens on a day-to-day basis. And many times that is actually a key thing for smaller businesses. For larger ones, they totally understand and they heavily invest in protecting their IP. Whenever I look at the KIPI release, the booklets that they usually give at KIPI is the Kenya National Property Institute. Most trademarks, patents, you realize these are being done by large corporations that understand the need for this. However, there's a need to impress on smaller companies the need for IP protection. Then, of course, enforcement issues. Fine, you protect your IP, but sometimes you're not so sure that if I spend all this much, if I seek to enforce, how soon will I get reprieve? That's usually a key issue. And then, of course, with emerging technology, there are other IP challenges that happen, like, for example, cyber squatting and the redress. Redress, again, if you have redress against trying to seek redress against the IP that has been infringed on usually becomes a challenge, because sometimes where do you start? Who do you engage? A lot needs to be done in terms of valuation, and not just valuation, but creating valuable IP. I think I've touched on this in the issue of data governance, but also a huge part of it is recording, keeping very good records, such that when audits are done, you're able to now place, is this going to be a trademark? Will we patent this, or will we copyright this? How will you know if you don't have a proper audit of your initiatives as a business? So there's a need to create a valuable IP. And then, of course, then after that, when you've done that, is now working the rounds of valuation. What does it mean for business? And I think if businesses worked on valuing their IP, they'd see the need to invest more in it. However, the challenge happens is that I think globally, the number is about almost 90% of expenditure in IP, people are not able to recover using that particular product. So sometimes there's that dampens the spirit for businesses to actually protect their intellectual property. But there's a lot of guidance that is required. And I think I'll start there for now. Yeah, I'll stop there for now. Catherine, have I adequately covered the question, or are there more that you feel that we need to add?
You have, and I'll pick up as we go. And maybe one clarification that I wanted you to point us in the right direction is where, you know, in you developing your IP, say for instance, a software company, and you have in-house developers, and so you had someone to come and, you know, develop a solution for you. Mm-hmm. What are the challenges experienced by businesses? Where, and we've seen these scenarios in Kenya where, and I think Dr. Kakuza also alluded to this, where I brought Rosemary on as a developer to develop something for me. I paid her, I did everything, but then later on, Rosemary goes and says, you know, that's my IP. Have you seen this, and how can also companies address that, or businesses address that as a challenge?
That's a very, very good question. And you see, it's rampant. Sometimes you have a brilliant idea and you don't know how to code. So what do? You get somebody to help you with that part. And when they do that, now they feel that they have a part ownership over. I think what needs to happen is that businesses need to be aware about properly contracting technology suppliers. This should be put right from the NDAs, and also strict clauses in terms of the employment contract, stating that all the work that you do will be the IP of the business. Because many times these would not have been developed without the input of the creator. IP, again, as you go strengthening your code, it wouldn't have been available if you hadn't been exposed to the environment in which that business operates. So I think there needs to be more stringent enforcement of this, and for companies not to be held hostage. And also maybe technological know-how is also important, like maybe getting a way in which development can be done in a secure environment. And this actually means having things like device policies in companies, how you store, where you can work from, access keys to maybe the portals where you develop your code. I think those are some of the things from a technical perspective. You have the physical that you can do, you have the contracting that you can do, but also it means that if you're going to get into a business that develops IP out of technology, you must also equip yourself adequately, such that even if somebody leaves, you open for them the source code, kindly proceed from here and move on. Yeah, I think for me, that's the best approach in terms of getting the technical tools that will help you ensure that your IP is protected. And yeah, and I think there's been enough precedent, I guess, not just globally, but even in Kenya, about where the ownership sometimes should not be disputed. The fact that you've helped me build something doesn't mean that it's yours or that we share it together. And that makes very many entrepreneurs shy away from it. They'll be like, the guy will just leave with a flash disk and I'll have nothing to do. But it doesn't have to be a flash disk. It can be something else. It can be a cloud server that you have access to. So I think in whatever field you want to play in, first equip yourself in the knowledge of how to protect it, then now dive in.
Absolutely, absolutely. I love that. And sometimes it's, I mean, as you said, the basics, if that developer has a form of contract where I can easily show that I had them, I issued them with a contract, they were my employee, and at all times, this was part of their JD or what I had them to do, then automatically I'll be protected when, you know, they start saying that this is a solution. So it goes down to the basics. How can you what can you use that's available in the law to protect yourself? Sometimes if they develop something, say maybe it's copyright, can you use assignment? Can they assign it to me? So what paperwork do they also need to do after they've developed for me? So I like that. Thank you for that, Rosemary. We'll come back to you with follow-up questions. And just to remind our audience, you can keep typing your questions for our panelists today, because we'll have a Q&A follow-up questions later where if you need them to clarify certain points or certain issues that they've brought up, please type your questions there. And Rosemary, thought we allow you to take some water before you come back to us. Maybe we can move on to Leila. Leila, maybe the question to you is, looking at the tech startup ecosystem in East Africa, in your opinion, what role does IP play in attracting investments and fostering growth for businesses in the region? And then once you answer that for us, then you can tell us, how can the startups effectively utilize their IP to then gain a competitive advantage in the market? Over to you, Leila. Leila, over to you, and you're on mute.
Yeah, thank you, Catherine. I will start with responding with what is the role of IP in attracting investment and fostering growth for business in the region. In East Africa, we do have technology startup with invention and innovations, but often these startups do not have to take proper advantage of this innovation and consequently see their growth slow down. The cause vary, and ignorance of the role of IP in business growth is one of them. Many startups are less concerned about intellectual property and allocate a large part of their budget to other businesses' needs. Our research showed that in East Africa, the top 3 priorities for technology startups are investing in equipment, entering new geographic markets, and product development. Yet, IP plays a very important role in attracting investment and promoting business growth. A technology startup, intellectual property is usually its most valuable assets. The products and services it brings to make market will help it gain market share and generate revenue, but neither market share nor revenue will be guaranteed unless the company can prevent other companies from stealing its concepts, brands, and invention. In technology startup, there are 3 IP rights that are most used, such as patents, trademark, and copyrights. I'm going to explain the importance of the 3 IP rights. That we start with patents. Patents protect new innovation for a startup company. Patents are a competitive advantage because they guarantee the uniqueness of their products or services. A patent gives its holder an exclusive right for a limited period to prevent others from making, using, selling, offering, for sale, or importing the patented invention. It's therefore a defense mechanism against infringement by competitors. Also, patents can significantly improve the valuation of a startup by serving as a tangible evidence of the organization's inherent innovative capabilities. They demonstrate to potential investors and peers that the startup has a unique and irreversible technological asset, making the investment and acquisition for more attractive. In addition, patents can generate income through licensing, which is another source of revenue for startups. So startups should see this as an investment to safeguard their technology assets, strengthen their market position, and pave the way for future growth. I will be talking now on trademarks. Trademarks serve as the face of a startup, distinguishing its product or services from those of its competitors. The primary role of a trademark is to let consumers know the source of a product or service, which assures them the consistent quality they can expect from a startup, which helps build trust and loyalty over time. Also, a strong trademark can contribute greatly to the valuation of a startup. It's become an intangible asset that only reflects the reputation of the startup in the market, but also its future revenue potential. Therefore, it's essential that startup companies carefully select and protect their trademarks. The role of copyrights. Copyright grants authors exclusive rights to distribute, display, and create derivative works of their original creation. An important aspect of copyright is that it does not protect ideas, but rather the expression of the ideas. Copyright plays an essential role in maintaining a startup competitive edge by preventing unauthorized use or copying. They also constitute an intangible asset that increase the value of the startup for potential investors and acquirers. So these IP rights should not trade these laws if they are not protected. So how to protect the IP rights? IP rights can only play these roles if these rights are protected. Protection ensured only when these protection is ensured only when these IP rights are registered with the relevant institution, and this must be done quickly to prevent others from registering them fast and gaining ownership. In addition, startups should use non-disclosure agreements to ensure that they can restrict the appropriation of confidential information about their innovation by staff or third parties. But there is a challenge associated with protecting IP rights. This is the cost of registering them. To solve this, startup can first locate the vital market and protect the IP rights in this location. To respond to the second question, which is how can startup effectively to raise their intellectual property to gain a competitive advantage? Firstly, as I have just said, you need to protect your IP to secure your business. The first step is to identify the company's intangible assets and determine the most appropriate form of protection. For example, a technological invention could be patented, while software will be protected by copyright. It's then essential to put in place legal protection strategies by registering patents, trademarks with the relevant bodies. Business secrets require internal measures to protect their confidentiality. Protecting intellectual property enables startups to secure their competitive advantage, prevent their innovations from being copied or used without authorization. It's also an asset when negotiating with investors or partners who attach great importance to the longevity and exclusivity of the solution proposed. Secondly, you need to enhance the value of your IP in order to raise your profile and generate revenue. In addition to legal protection, it's important for startups to promote their intangible assets in order to maximize their impact on the market and attract the attention of customers, investors, and the media. Communication around intellectual property can take several forms, such as displaying patent spelling or patent number, registered trademark logo on product packaging, commercial and marketing documents, and websites. Also, you may promote innovation or creation at trade shows, conferences, and social networks. Intellectual property can also be a direct source of revenue for a startup through the assignment of granting licenses. This involves authorizing a third party to exploit a patent invention or a work protected by copyright in exchange for a one-off payment or royalties proportional to sales. This strategy enables the company to recoup investments in research and development and increase its geographical reach out, incurring all the costs associated with expansion. Kabri may manage your intellectual property rigorously and proactively. To make the most of the intangible assets, startups need to adopt a proactive and rigorous approach to managing their intellectual property. In particular, this means technological and competitive intelligence to detect opportunities for innovation and the risk of infringement, taking legal aspects into account right from the design stage of project to avoid intellectual property conflicts and optimize protection. To conclude, intellectual property is a crucial issue for a startup, which need to protect and enhance their intangible assets to ensure they success the marketplace. Or a well-thought IP strategy not only secure the company's business, but also increase its reputation and revenue. Therefore, it's essential to devote necessary resources into it and they rely on experts to optimize its management. I think I've tried to answer your question. Over to you, Kathleen.
Oh, thank you. Thank you for those insights, Leila. So maybe we are going to continue later in the second session. Maybe you're going to continue with the concepts that you just started a bit later. So if you allow me now, maybe we can jump to Kama. Kalebu, Kama, to you. Maybe the question we would ask is, as a lawyer who has worked with entrepreneurs who've successfully commercialized IP rights in East Africa, what then are some of the key steps and considerations that businesses should take when planning to monetize their intellectual property assets in the region?
Thank you, Catherine, for the wonderful job. I also thank Dr. Kakoza, Rosemary, and Leila for the wonderful visit. It is very assistance on this matter. And because of the crucial aspect of this question, I tried at least to prepare some summary on the main points to consider before commercializing intellectual property. And allow me to share it. Yes, as you can see, there are some special matter which a company or an individual need to consider before starting commercializing IP rights. Taking into consideration that here you mean getting profit from your idea, your new idea, which you have at least taken some measures or some steps to develop the same. Now, intellectual property, as our previous speaker said, it can be a product or goods, or it can be a service. So there are some measures or some special factors you need to consider before taking your product or your services into the market. And this factor are divided into there are internal matters and there are external factors or matters also you need to consider. Now, the first issue which a company needs to consider before starting to commercialize its intellectual property right is the issue of business objectives. The company or an individual need first to evaluate itself what it intends to get from developed intellectual property right. Maybe, let's say, the company A maybe need to get some amount in its developed IP asset, or need to go more in a different country. Now, those are the objectives of the company. So the first issue the company should consider before starting commercializing intellectual property rights is the issue of objective. The company must have internal regulations and the description on what they intend to get from the intellectual property before going to the market. Now, the second issue which the company needs to consider is the issue of IP rights. Now, as I said before, there are different types of intellectual property. There are trademarks, there are patents, copyright, industrial design, utility model, and the like. So the company needs first to consider this issue. What kind of intellectual property right you want to bring to the market? Because this will help you to make you choose the right way to go to the market. Because bringing, let's say, a product into the market is different in bringing services into the market. So as a company or as an individual or an entity, you have to consider this aspect first before going to commercialize your IP assets. And the third issue which you need to consider is the issue of economic and human capital. You need to know how much are you have in terms of funds, how funded enough are you to make your product or service marketable. And how about your human resource? How about human resource? How many people you have? How many people know intellectual property? How many people know marketing strategy? So these are some crucial factors which a company or individual need to consider before going to the market. And another issue which a company needs to consider is the issue of competitor, because there is a saying that you dance according to the tune of the music. You don't go to the market without knowing how you dance in the market. So you have to know your competitor. For instance, if you are producing, let's say, maize, you have to know your other competitor who produce maize so that you can know maybe their weakness and their advantage. Their weakness and their advantage. So you have to know all these factors so that if you go to the market, you bring new concept apart from the already available product in the market. Or if you are intending to bring services, also you have to know other services provided in the market, so that if you start offering your services, you differ from the already available services in the market. Now, the other issue which you need to consider is the issue of legislative policy framework. Now, this is the crucial part, and this is more sensitive issue because you have to know each and every aspect of law governing intellectual property right. For instance, we have different laws which govern this intellectual property. If you deal with trademark, there are laws which govern trademark. If you deal with patent, there are laws which govern patents. And if you copyright, also there are laws governing copyright and the policy. So you have to know all these factors, all this law and the policies before going to the market. For instance, now we are talking about East Africa, and as you know, intellectual property is not an international matter; it's a national matter. So you have to know if you want maybe to trade in Kenya, you have to know all the laws relating with intellectual property rights in Kenya. And if you are not be able to know all of this, you can use IP expert in those in Kenya, or if you maybe you want to trade in Tanzania, then you have to know respective law governing intellectual property right in Tanzania. So this one will help you to know the best and the best modality of going to the market. And if you skip this step, then it will be in a difficult position. Then the other issue is appropriation, and these are external factor. And as you know, appropriation is a key aspect in marketing. So you have to know maybe you want to sell your product A, or you want to sell your services. Now you have to consider how much people you want to buy your product, or how many people you want to consume your services. So this is a key factor to consider. And as you know, maybe you want to sell your new brand mobile phone, and you want the same to be consumed by maybe 1,000 people. Now you have to consider good population where your service or your product will get used so that you get more profit. So these are some of the special factors to consider before starting commercializing your intellectual property. Thank you, Catherine. Maybe I think I've answered your question for it. Thank you.
You have answered my question. Thank you very much, Mkama, for that presentation. So now that we've, as an audience, we've understood the basics of what intellectual property is, and then what commercialization of IP is, which for us, I think what we've understood, it doesn't only mean, apart from you securing or registering your IP, there's what people do to commercialize intellectual property. And I think one of the things that we now practically, when we come back as lawyers, because we are all lawyers of our different bars here today, maybe we can look at, and I'll throw this question to Dr. Kakoza, coming back to you. Within our own legal industry, we've seen law firms that are, leveraging on their intellectual property to probably, franchise or expand to other markets and lend their, intellectual property, which I'm sure there are, all this arrangement behind the scenes, where you can see like a South African law firm is now expanding to the other African markets. So then I want you to link that, if you can paint a picture for us and link that with the subjects that we're talking about today, to just bring it closer home on how our own industry, legal industry, is affected, or how it's influenced by, commercializing of IP assets.
Okay, thank you, Catherine, for that question. I think the legal industry has a lot to benefit from the commercialization of IP cross borders. As a practice, as legal professionals, our practice is territorial, in the sense that if you're Kenyan, you can only practice in Kenya. If you're Ugandan, you can only practice in Uganda. But it's not close-knit in that sense. We can still go over to Kenya and get a specific license to handle a particular case. And I believe it's the same thing with Kenya, that you, under the Ugandan legal system, you can't come and get a minister's license to handle a specific case. And it's the same thing in many other jurisdictions. But nonetheless, when you're looking at businesses that are crossing over in other jurisdictions, and now you're looking at law firms, ENS, which is in many parts of Africa, DLA Piper, which is in many parts of Africa, and the like. There are many benefits that go with this. Starting first of all, that these law firms have to look at how they're branding themselves. And what is really helping them out is they're already big in the legal profession. They're known across jurisdictions, the likes of the ENS and the DLA Pipe and the rest. So when they have bases established in particular jurisdictions, the companies in those places would recognize them and know that these are people that we can work with because we've seen them in other places. And when we want to expand our businesses to those other countries where they are, we will continue working with them. So this is one benefit that goes to cross-border legal practice. And in any case, it's not that you pick up one lawyer from one country and take him to another. They just establish a base there and allow you to use their brand, which is the same thing as the example I presented earlier of the likes of Yum Brands, which is the owner of KFC. They don't carry their employees to different countries. They just get local people there and allow them to have a franchise for KFC in the local places. So franchising extends to the legal profession, and it means that we're utilizing intellectual property within legal practice. It's helping for tapping the market, grabbing the markets, and it's part of consumer confidence. That's the specific consumers that identify with particular law firm brands and would want to work with them when they see them expand to these places. So that's the short answer. I hope that.
Yeah. I think now you're bringing it closer home. Rosemary, over to you. We've seen also, give us examples, practical examples of brands out there, whether it's in Kenya, within Africa, whether it's multinationals. Give us examples to just paint a picture of brands that have perfected the art of commercializing IP as an asset, and to just paint a picture of practical examples and how they go about this, because I think as lawyers, we're trying to understand the workings also behind painting a picture of what, as lawyers for supporting these businesses, then how would we support our businesses to commercialize, these IP assets?
I think I'm happy that there's an example that has been used a number of times, and that the Yum brands. I think for me that's a classic case where you were able to cascade yumminess to the world all over without having to move products, just moving what is important in order to get it delivered. However, I'll tweak it in a different way, in terms of how has IP been used as you grow your business from one level to another, and even how do you help it in terms of transition. I'll give an example. Kodak was a specialist in making cameras. That's what they did for the longest time. However, when technology disruption came up, they were able to leverage on what they were really good at, as other businesses were starting to purchase those functionalities. And we've all seen the picture where you have a phone that has swallowed up a calculator, a camera, a computer, and all these other things. So Kodak sold its digital imaging patent for $525 million to Apple, Google, and Facebook. If they hadn't had that well recorded and well utilized, then they would not have made a benefit from that. I think there are also other companies like AOL, which sold, I think, over 800 patents to Microsoft in 2012 for, I think, 1.1 billion. So these are classic examples of where IP will come to assist you in the work that you're currently doing, but will also be a safety net in whichever eventualities that happen in markets. Of course, in African markets, what we find is that we are mainly recipients, where we get licenses, where we get, in this case, recipes, we get technological know-how. I think what we need to start thinking very differently is that the advantage of being in Africa is, for the first time, you can develop nascent information that is unique to this market, that we can then commercialize and sell to multinationals. And I think for me, the beauty about it is switching up the direction of IP funding. Instead of us paying outside for IP, why don't we get as much insights as we can in these markets, and then commercialize that, and then transport that and make make a lot of value for businesses that are occurring. And I'm happy that there are amazing brands that are there in this market that are doing amazing things. I'll mention companies like the Cab company, moving from one product that is just carbs to then even moving into food, ordering of food, and various other things that, creating a whole ecosystem. Today, we even see that you can get early bird tickets at 30% lower. So it means that you can actually make use of your IP, and even as you grow your portfolio, as you grow your business, you can utilize your IP for different business opportunities, but also just going out there to capitalize on what best it is about your customers, about your products, and let's utilize this to create a market for IP, where we're actually exporting our African insights, as opposed to us always being the recipients.
Right. That's very insightful. And you've alluded to, in all these things, there's the back end, considerations that should be made, or the things that are done in the back end to just see whether it's partnerships, whether it's licensing agreements, all these things that would need to be done in the back end. What do you say are some of the legal considerations that businesses should keep in mind when negotiating, say, licensing or partnership agreements related to the IP assets? And this is, within East Africa, or just for everybody.
I think that's a very, very good question. And it's usually, it's the basic legal things. You want to go out of the box and come up with new things. You look at it, the term the term of a contract is a very basic legal concept, yet it becomes very critical. If you're licensing to somebody, you need to protect yourself. Make sure that you're not locked up in perpetuity, and that it even helps you to continue assessing the value of the IP. Today, if it was worth, say, 10,000 Kenyan shillings for us to license to you for a month, as it grows, we should be allowed to double that in the next 2 or 3 years. And the best way you do that is by looking at the term. Of course, I've mentioned value consideration. Things like how much does it cost? Those are some of the key things that you should look at. And being able to critically evaluate as your value grows. How then are you allowing yourself in the contracts that you get into to continue harnessing the improvement of your value? And then, of course, key things are confidentiality. I don't think any of us have drank Coca-Cola for so long, but we have no idea what is used to make it. I think for me, that is also essential, and also goes with what you had mentioned, the question that you had asked earlier about employees and the third parties that you utilize in order to develop these products. Confidentiality then become very key concepts that you look at. And of course, seeking, and of course, I'll mention again, data protection has come in. Many times, I think I had the issue of a client list being mentioned as IP. Very good, very nice. But data protection laws nowadays come in to protect those data subjects, to ensure that their data is not shared with third parties where they had not given consent. So these are old things, and they're also emerging things. However, IP law and even IP as we know it is being disrupted by technology. Allow me to throw in interesting things like AI at this point. How then are we protecting ourselves? Are we engaging in enough surveillance to make sure that, you know, our works are not being compromised? And we've actually, and even in the building of your products, you need to check for how then do you create ways for the public to reach out to you, or maybe for you to engage with stakeholders whenever they feel that their IP has been infringed. We've seen in platforms that we like using, like YouTube, where they actually allow you to flag, and where they even utilize things like AI in order to secure the various IP from various companies. So for me, I think I'd say let's always look at basics. I think as law emerges, as technology advances, one thing I keep saying is that the principles are always the same. There's never too much evolution, but it's always looking at the terms that you have, and then how then do you tweak those to respond to the issues of the day.
I love that. A good IP lawyer is a good commercial transaction lawyer. So exactly. The basics are the same with litigation lawyer. Thank you for that. Maybe quickly, Kama, from your experience, what are some effective marketing and branding strategies that businesses can employ to create awareness and generate demand for their products and services based on IP assets? Maybe if you can tell us briefly.
Thank you, Catherine. Thank you again. They allow me again to share the prepared inside. And for sure, you can decide to commercialize your IP assets either as an individual or as a business partnership. But all this, the two depend on what you need. As I said from the very beginning, that you have to know what do you intend to get in property assets. For instance, the company may need or may wish to commercialize its IP as an individual or private because they have enough capital to do the same, or they have enough people to marketing it. So if this company has enough capital, then it can do alone. Or if it is enough, it have enough people, maybe experienced people to do marketing, then it can do its own. But if the company, for instance, this small and medium company, they wish to adopt this business partnership because this one is more easy and maybe it brings cost and also an issue of human capital. If your company does not have enough people, then you can adopt this business partnership. Now, in this business partnership, it depends. It can be business partnership between the company, maybe company A, agreeing to do commercialize IP asset with company B. Now, in this case, they will sit down and they draft an agreement which will be regulating this business. Or it can be a business partnership between a company with the government. For instance, here in Tanzania, we have different entities which regulate this business, intellectual property right business. For instance, we have the COSOTA, which deal with all which related copyright and artistic works. Also, we have this BASATA, the National Arts Council of Tanzania, which also regulates this business relating to intellectual artistic work. So a company or an individual may wish to make a partnership with the government, which will help them to commercialize this business, or a contract, a business partnership between an individual and the government, as I said, or individual again, either the company or individual, the company, or the government. So all this are the means of doing business. So if the one choose to do business or to commercialize its IP asset by using business partnership, now they can see where they need the same to go through licensing. Now, this is the most effective in the current market, whereby different companies adopt this licensing as the means of marketing their product. Now, also this depends on your motives and what you need to get from that IP asset. Also, you can also choose franchising. Now, this franchising is a win-win situation. Maybe you have your product and you want the same to be sold in different countries. Maybe you have a product in Tanzania, you need the same to be sold in Kenya, but you don't have enough capital or enough people to sell your product. Then you can decide to make a business partnership with somebody in Kenya or with a company in Kenya through franchising agreement. And the profit you get there, then you divide it equally. And the other means which also can use is spin-off company. Now, this is the way in which whereby you establish a new company or an entity to run your business, your business. Now, this depends also with what you need to get from your intellectual property rights. Thank you.
Oh, thank you so much for that, Mkama. Maybe we can move to Leila. And Leila, in your interaction with startups within East Africa, what would you say are some of the misconceptions or challenges that they face and regarding commercialization of IP rights, and how can they overcome them? In 3 minutes, maybe you can tell us in 3 minutes so we end up.
I will start by telling you a story that I've heard where a distributor wanted to register the brand as the owner of that brand. So you see, this is the lack of knowledge in intellectual property. How we should overcome this, government should provide to entrepreneurs through their IP institution with awareness session on IP. And on the side of the startup, they have to rely on intellectual property experts. Because you know, the commercialization of IP is certainly not an easy task. So to see the success of this process, they have to look for experts. So they will tell them what strategy to take, what is needed, what is good for them to see their IP being commercialized. Yeah, that's my answer.
Wow, thank you for that practical example, and that's quite insightful. So I see we are pressed for time, and I've asked a lot of questions that our audience asked. So maybe so that we wind up, we'll just give closing remarks to each of the panelists in case there is any insight that they wanted to share with us and they didn't get an opportunity to. But you can give us the closing remarks. We can start with Dr. Kakoza.
Thank you very much, Catherine. I had written down the questions that some of the participants had asked. So maybe I'll just quickly run through them and give quick answers. Motari Leonida had asked, is it a necessity for a community-based organization to be trademarked? And my answer was yes, because when you trademark your IP, then of course you're protecting it better than someone who just runs the business without any form of intellectual property protection. But here we're looking at community-based organizations. And a community-based organization can protect the intellectual property either through a trademark or a geographical indication as the topmost. There may be others, but those are the two topmost, because with both the trademark as well as the geographical indication type of IP protection, you would have either certification marks where different people within an association are all certified as producing the same kind of product. And as long as they belong to that group, they have a certification mark for the trademark. Or you can have collective marks where, again, you're bringing these people together and they're fulfilling certain qualities in what they're producing to get the IP. So that answers Motari. There was another question about what are some of the stringent provisions that should be put in place to guard commercialization. And the short answer to that, it goes back to what I said. It's important to do an intellectual property audit. The audit would involve documenting and looking through the documents that relate to your intellectual property ownership, how it has been used and how it has been put into the market. You do an IP valuation. There was another related question on what does it mean to do an IP valuation. You look at either cost analysis or market analysis or income analysis. Any of those three would guide you as to how the money has come in related specifically to your intellectual property. How much did it cost to create it? How much is it in the market, depending on what you charge or what your competitors charge, or how much does it bring in terms of income? Then you also need to do a due diligence on licensing and assignment agreements, if they're effective and how they're being utilized. You have to evaluate your enforcement options. And this would mean, are you going to sue someone who is trying to infringe, or would you rather sit down on a round table with this person and offer him a licensing agreement, because it would be cheaper than going to court where you may be for the next so many years. If you read the book Shoe Dog by Phil Knight, the person who founded Nike, he talks about a time when he thought about suing someone who was infringing on the Nike brand, but decided to just give this person a licensing agreement. So those are some of the things that you think about. Then you also have to decide on the most effective type of intellectual property rights to register. Would you rather go with the patent, which will give you 20 years of protection, but you have to give full disclosure as to how it works? Or would you go for trade secret, where you don't have to register anything, but you keep everything confidential? And as long as you keep this as a secret, like we'll be talking about, Rosemary, I think, was talking about the Coca-Cola formula, then it would run indefinitely. No one gets to know about it. So Coca-Cola and KFC are some of the longest protected trade secrets out there. So these are some of the stringent provisions that you find with intellectual property brands and commercializing of them. I think that basically answers. Let me see, there's Dean Mwanda asking, must all IP be registered to be protected? Not necessarily. You can register copyright, or you may decide to just stick with how the copyright has been formed. As long as you've put it into a fixed form or some form of expression, then you have copyright. Registration would just be for evidential purposes. And like I've said, trade secrets don't require registration. Eloid is asking, how do you conduct valuation of IP? I've already talked about that, the cost or income or market type of analysis. And Claire Kirera is asking about the challenges of licensing innovations. Some of these challenges have been mentioned, but you can think about, for instance, what they call freedom to operate. someone may go around your intellectual property and see other ways in which they can do what your creativity is really meant to be doing, but they won't be sued for infringement. So those are the FTOs, the freedom to operate situations that you have. They're kind of similar to someone who reverse engineers your trade secret and finds out how it operates, but because he has discovered an independent way of doing it, this kind of blows up your trade secret and you no longer have it as a trade secret, just like what happened with the formula for Listerine, the mouthwash. Someone did an independent discovery, and that was the end of the trade secret for Listerine. And then understanding IP durability is another challenge with licensing. It's easier to license a patent which is in its early or nascent stages, and it has a long period to go, or the 20-year period, as opposed to licensing a patent which is about to end on its durability. But then you can also think about other ways of protecting your IP when one form of IP runs out, like what recently happened with Walt Disney Company. The Mickey Mouse brands and all those Donald Duck, the copyright has expired, but they're now looking at protecting them using trademark, which can run indefinitely. So those are some of the challenges to see how to go around. Then, of course, you may also have evergreen patents where once one patent expires, you find another use for the same product that is seen as innovative. So then you apply afresh for another form of patent there. That can be seen as a licensing challenge as well. And lastly, understanding exclusive or non-exclusive licenses and the accompanying rights. Who has an exclusive license and who has a non-exclusive license can be quite tricky unless you've crafted this well in an agreement. So IP valuation, IP commercialization is a very interesting and fun area. Many of us who are in practice and do it occasionally love it, but you have to keep at the edge of your seat to ensure you do it well for your clients. Thank you very much, Catherine. I hope I haven't taken too long in trying to explain this.
No. That was wonderful. It's worth the extra time that you've taken because, again, most of us came here to learn and to provoke our thoughts. So thank you for that, Dr. Kakoza. Rosemary?
Catherine, I'm here.
Yeah, give us your closing remarks or any insights, or if you saw a question and you will have, you'd like to give additional insights into what Dr. Kakoza has answered, feel free.
Okay, asante sana. So I guess, I think for me, the one thing I felt that I needed to mention when reviewing those contracts is the question that you had asked about contracting is about scope and exclusivity of licenses. I think that is so key, such that you don't give somebody your licensing in Kenya, then they go using it in Uganda to make money, and you haven't agreed on that. I think for me, that's a very critical one. You need to be very clear on the territorial scope of licensing. I think that's one of the key things that I really need to mention that. And of course, in terms of creating valuation for IP, it's about looking at the wealth that you create for the business. Of course, there are tangible assets and intangible assets. And the thing with an IP, intangible assets, you either create value, one, through a legal provision, like those licensings that you do, but then also value is created from the value that is created by the product. The WIPO site has quite a number of suggestions in terms of how this valuation can be done, and the various categories, and even the calculations that are done. I think somebody has mentioned them as being fun. So reach out to the fun people to explain that and how it is done. But I think it is so critical. As we said, if we're to move as a continent to be a net exporter of IP, as opposed to being a net importer of IP, we must get our hands down to actually realize what are the things that we need to do in order to ensure that that we have protected the IP and that we know about it, and that we create the utmost value for ourselves, our countries, and even our businesses. So I think for me, that's it. And of course, keeping in mind the developments that are happening. From a data protection perspective, from an emerging technology perspective, and how are those impacting how we do things. We are seeing renditions of songs being done by artists who haven't sung them. And that is through large language models that are just coming up and actually building new songs and new things. So I think as IP progresses, we must also be very careful about the technological nuances and the challenges that are coming as a result of emerging technology, and then moving to the next best thing and asking, how do we protect ourselves in that regard? So thank you very much. And I think that's my closing comment.
Oh, thank you so much for that, Rosemary. That's very insightful. Mkama, do you have your closing remarks or any insights?
Thank you again. I think there are one question which I remembered on my part on whether there are any specific or sector in East Africa where commercialization of intellectual property rights has been so significant or growing. Now I think there are some sector which has now been made as the best sector to do business. For instance, the issue of sector of telecommunication, I think this one is doing better in the current East African market. And the other sector is food, and the drinks sector is also doing very nice, very wonderful in the market. Also, this medicine issue, medicine and the medical instrument. Also, this is the best sector which have been doing in the market in East Africa. But another issue which I will also want to add is the issue on important factor to consider when drafting commercialization contract on the issue of royalty. I think now parties, when drafting this contract, they need to be more specific on the issue of royalty. They have to show how someone is going to benefit from that contract, so that you can draft the same today, you see that simple, but tomorrow start to cry. So it is best to put clear on the issue of royalty. Another issue which we also need to consider is the issue of duration. Now, this is the main factor also which you need to be careful when drafting contract, commercialization contract. For instance, you may take your IP today, does not have any value, but if you come in 5 or 10 years, you put in yourself that you have gained more value. So if now you have not indicated the duration on your contract, then that one will be benefit. It will be difficult to you and will not get the benefit of your idea. So it is best at least to make sure that you put the duration of the contract in the big step. This contract may be for 2 or 3 years, then renewable after 3 or 4 years, then that one will be okay for you. Thank you.
Well, thank you very much for that, Mkama. Leila, do you have any closing remarks?
Yes. I would say that IP is one of the pillars of company competitive advantage. So in looking at the evolution of technologies, companies need to understand well and effectively manage their IP so that they will be able to compete in a marketplace. So they need to take in one of their priorities, IP strategies. Thank you.
Oh, thank you for that, Leila. And thank you very much to our audience. Now I'm going to hand over to Sunday to conclude and close the webinar.
Thank you, Catherine, and thank you to all the panelists for their contributions. The insights are very much appreciated. But I think we still have questions, so we'll open up the floor. I saw a hand raised by Mary, so I'll allow Mary to speak if she has a question, and then we will take it from there. Mary, are you with us? You had a question, you raised up your hand. You can speak. If anyone else in the audience has a question, please raise up your hand and we'll allow you to speak. But also, as we wait for Mary and other participants, oh, there is one hand. I will allow you to speak. 1 minute. Yes, Car, please ask your question. Go ahead.
Thank you so much. And I thank the panelists, the moderators for a very good job. Well done. Actually, I just need a clarification if there is any possibility where there are some IPs that cannot be protected. For example, let's say mathematical formulas. Could those be protected or not? And why not? Thank you.
Okay, so who would like to respond to that? Anyone, Dr. Kama, Rose?
Mathematical formulas. Thank you, Sandy. Let me respond to that. Although intellectual property is territorial in that where you protect it, where you register it is where it is protected and you follow the laws of that country. Most countries have similar or synergies in their intellectual property laws. So the patent system in a global sense has mathematical formulas as non-patentable. In Uganda, in Kenya, in Tanzania, and pretty much every other jurisdiction, they're considered as not protectable under patent law because if you give it patent protection, then you'd be restricting anyone who tries to come up with a formula over a mathematical product. And this is something that is considered as drawn, not necessarily out of nature, but anyone can think them through and create these formulas and then utilize them. So if you make it restricted, because the intellectual property legal system is what we call a negative right, that you're giving someone ownership over something and denying it of others, but they can use it under terms and conditions given by that individual, which would be that either licensing arrangements or assignment. So the stretch in all that is that if you create a monopoly around mathematical formulas, then you're stunting the growth of science and technology. So therefore, this is left open. I hope I answered that.
Yes, you have. Yes, you have. Let me allow Gonzaga also to shoot. Gonzaga, go ahead. Gonzaga Mombeki. Gonzaga, you raised your hand. Kama, you wanted to add up to what Dr. Tony has said? Go ahead.
Thank you, Mr. Sanders. I think there was one question which was asked by one the issue on how it can balance the issue of public interest and intellectual property. Thank you for that question. And if you go to the TRIPS agreement, it provides the issue of public interest in intellectual property rights. And in this, we speak much on copyright, the patents, and the trade secrets. Now, under the TRIPS agreement, it provides a modality in which a country can at least provide, make its own law on how the interest of public with that of the inventor or the owner of intellectual property will be regulated. So it is a matter of specific or national or one country or the another to enact some provision of the law on how they will be regulating the interests between the interest of the public, that interest of the owner of intellectual property. Thank you.
Thank you very much, Mkama. I'm not so sure Gonzaga is with us and you can ask. If not, I move on. Gonzaga, I'm giving you another chance. Perhaps if you are back online or you can unmute. In the meantime, there was one thing I'm not so sure if we touched on. Catherine, I wanted to ask the panelists. The issue on using IP assets as collateral. I wanted to get your experience, Doctor, and the rest. What is your experience in your jurisdictions, Uganda, Kenya? I know Kenya, there was a piece of legislation that was passed in as far as collateral are concerned, but I'm not so sure as to its practicability or applicability. Perhaps I can start with you, Doctor, and anyone else in the panel who can give us an insight so that we get to understand.
Thank you, Sunday. So in Uganda, we have a legislation that came up in 2019, Securities in Immovable Properties Act, SIMPA. And we have a registry at the Uganda Registration Services Bureau, which is the National Intellectual Property Office, where they have a specific department, the SIMPA department that handles such matters. Basically, what happens is that, of course, you'd have to have a registered IP. And the proof of registration is your certificate. So you go through that office to show that you have this IP, and you'd have to show that there's some generation of income through that intellectual property. And once all that, there are certain steps that happen through the SIMPA registry, then they would work with the financial entity that would present this IP as collateral. So I have my trademark certificate. I show that there's this value that I'm obtaining out of my trademark. I work with the SIMPA registry, and then they connect with the bank that I want to get a loan from. And then the bank would be satisfied that, okay, there's a certain funds coming in through this IP. We can then lend this person money to this effect. I'm not sure if this has been practicalized in any sense. I almost went as far with one client, but we didn't complete the transaction through SIMPA. But I don't know if this has been effected with any other entities, because in the Ugandan sense, banks are still shy of using intellectual property as collateral. They're not yet so convinced that there's enough continuous generation of income out of this. And yet I would love to see this being practicalized at some point. And I do believe it will happen.
Maybe I can speak to that in terms of Kenyan legislation. I think we also have immovable properties regulations. One of them is a stamp duty for immovable properties that was given in the year 2020. And one of the things that is requested is a cadastral map of where the immovable property is located. Now ask yourself, if you've stored your IP in a cloud server, say for example, the AWS, Azure, or any other technical, how then would you answer that? I think we need to reflect on some of the ways in which we think of immovable properties if IP is to be considered and well roped in from a regulatory perspective, especially responding to the technological nuances of how technological IP sits. There may not be a map, maybe there's a cadastral map of where the building is, but for technology specifically, I think a lot more needs to be done in terms of reviewing what that means, and also we'll then go ahead now in assisting with compliance. Thanks.
Okay, thank you. Come on, you want to jump in quickly, like in 1 or 2 minutes, please?
Yes, yes. From my experience in Tanzania, I think instead of different law which recognize this IP rights as an asset, but up to date there is no piece of legislation in Tanzania which allows this IP asset to be recognized as a collateral. and this is both in practice. I think the bank does not recognize this one as one of the assets, as a collateral asset in Tanzania. So this is, I think, is need to be developed in Tanzania. The same is not currently in practice.
Thank you, thank you. And from you, Burundi, what's the experience there? Leila? Sorry, I meant, yes, Leila, are you with us? What's your experience in Burundi? Do you have anything relating to collateral as far as IP is concerned? You have a law in place?
No. I think this is a item that needs to be developed in Burundi, and look at the level that Burundians consider IP. This is a wide path.
Okay, all right, thank you. So I'll take, I'll allow, so I see Sadat, you have raised your hand. I'll allow you to speak. If you have a question, please go ahead.
Okay, good morning. Hello.
Hello, yes, we can hear you. Go ahead.
Okay, thank you. Good morning. First of all, thank the organizer of this interesting webinar and the moderator. My preoccupation is not very far from the one of Darren. I would like to know if it's possible to keep a right on the product for a life. If not, in which domain is it possible to keep a right, to keep this type of right?
Right. If I got you clearly, you're asking if it's possible to keep a right for a product for life.
Yes.
In terms of IP, right?
Yes.
Oh, okay. All right. Thank you very much for that question. Anyone from the panel, would you like to respond? Please go ahead.
Well, I think it's
Leila, perhaps, or Doctor. Go ahead, Doctor.
Thank you. I think Sadat is asking about the IP duration, and this varies depending on the type of IP. For patents, it's 20 years. For trademarks, it's different in the different East African jurisdictions. For instance, Uganda and Tanzania, you first get 7 years and then 10 years consecutively. You renew every 10 years for an indefinite period. For Kenya, 10 years from the onset, and you keep renewing for every 10 years. Trade secrets run indefinitely in as long as it's a trade secret. So that also runs for, Coca-Cola has been a trade secret for over 200 years now. For copyright, it's for the life of an individual plus 50 years after death. But if it's a company that owns the copyright, then it's just 50 years. In most East African jurisdictions, that's the case. For geographical indications, it's just like trademarks. It's every 10 years. You just keep renewing every 10 years. For plant variety protection, not every East African country has plant variety as an IP. Uganda does, but here it depends on the type of crop. For perennials and territorial crops, it can be 25 years. And then after that, it goes into the public domain. So the short answer for Sadat is that it depends on the type of IP. Yes. Thank you.
Thank you. Anyone else like to jump on board? If not, I take another question, but you will have to hear your experience, let's say from Kenya. What's the time frames, copyright, trademarks, and Burundi as well, because that might be helpful to the gentleman who asked the question. Or Mkama for Tanzania as well. Tanzania and Zanzibar, the differences, if you could share your views on that.
Yes, Mr. Sand, I think Doctor has elaborated well on the issue of trademark. You get your first registration for 7 years in Tanzania, then renewal after 10 years. Now in Zanzibar, the same is different. You get first 10 years, then renewal 7 years. I think the other issue, Doctor elaborated it well. Thank you.
I think in Kenya it is 10 years.
Thank you.
Rosemary here. I think, the period, a registration is valid for 10 years from the date of application, and 6 months prior to the expiry of the 10 years, and usually the registrar will notify the owner. This is good. However, from global practice, a lot of research shows that many businesses fail to renew by virtue of, if you didn't realize the value of your IP earlier on, then many of them decide, look, this year we're not going to, say, incur the cost for this. And I think the thing is for considerations to be made by businesses to actually make decisions around protecting their IP. There's no point in having invested so much for so long. I think with the Kodak example, your technology might be out of use for now, but later it might still have a value. So there's a lot of value in ensuring that you always make sure that your licensing is up to date. Thanks.
Thank you very much. I don't see any more questions from the attendees. We still have about 15 minutes for us to wrap up our session. But I believe we have touched on a lot of topics in terms of like from startups and how they can, in as much as there are misconceptions and how the ecosystem can adapt to see on how they can use their IP assets. We have looked at companies, we have looked at different laws and as far as collaterals are concerned. But I wanted to get, let's say, from each one of you in 1 minute, from your countries, do you think there are any perhaps specific industries, yes, or sectors where commercialization of IP, let's say, is more significant, or you see there is perhaps growth in that space? What's your take, Doctor? Let's say in Uganda, what's your take? Where do you see perhaps if there is actually in practice? If not, where do you see, which sector? Could it be, let's say, in finance, in fintech? Do you see, let's say, in agriculture? Do you see in manufacturing? Where do you see in as far as your experience is concerned?
Thank you. That's a very interesting question. So it all goes with the type of economy that we have. Uganda is, to a large extent, an agro-based economy. So we have R&Ds, research and development institutions that are closely linked with the agriculture industry that are doing well. Not that those that are outside agriculture are not doing well. These are doing exceptionally much better as to how they're utilizing the research that they're doing and how they are working in collaboration with academic institutions, for instance. So there's one particular player called the Presidential Initiative on Banana Industrial Development, BIBID. This is a project that started, the person that started this launched this through Makerere University, and now it has grown to become a huge R&D institution of its own. Related to that, which is not in the agro-based industry, but is tech, is we have Kira EV project, which also started as a project under the Makerere University and now has grown into its own R&D institution, which is generating electronic vehicles. They've had quite a number of tests done on they've created buses, they've manufactured electronic buses and sedans and different other cars, and now they want to launch out and start manufacturing cars on a large scale. But the key thing that we're noticing in all of this is that they started as university projects. So there's a strong synergy and relationship between universities and what comes out as R&D institutions. Maybe we call them startups that are generated out of universities. And this is the biggest kind of story that we see even in the developed world, that many universities have tech parks just next to them and work well with students and lecturers and professors who help to generate ideas that become intellectual property, and then they just enter into licensing and assignments with with companies which launch out. YouTube, for instance, started as university projects at the University of Illinois, and then they sold that, the students who started it sold it to Google. So we have the same kind of story here in Uganda, that many university projects, for the Me to You, which is people sharing airtime, started as a university project among students here, although the story is not such a good story, but MTN took it on. So that's the general picture, really, to answer your question, that it's more of university projects that are feeding into the innovative industry that we have out there, and are building into intellectual property in Uganda that go out into startups and research and development institutions. Yes.
Okay, thank you, Doctor. Mkama, from your Tanzanian perspective, what's your take? Same question.
Thank you, Mr. Sand. I think to add on Dr. has been saying, in Tanzania, for instance, we have different institutions and the university which do conduct this research and the development. But practically speaking, they are not implementing the same. They don't offer them for selling. Now, you may find that the university do conduct research, but they don't commercialize it. And the reason is, most of the universities, they don't have this intellectual property policy. So if they do research and they discover something, they don't commercialize it because of lacking of this legal framework or policies, which will enable them to go will enable them to assist them in going to the market. Another issue is the mechanism. Maybe you find that they don't know a good mechanism on how they can offer the same to the market. And another issue is this university and different institutions, they don't consider the issue of having IP department, a specific IP department, which will be dealing with commercializing this research and the development. So they do research, they use enough, they use huge amount of money, capital, and the time, but they don't put it into the market like abroad university and institution. For instance, in my side, I can take as a fact, for example, I've been registering different patents from abroad, but I have never come across any patents from Tanzanian university. So you can see that is different, that is an issue. But coming to your question on sector which are gaining momentum as far as commercialization is of intellectual property are concerned, yes, we have different sectors which we see they are developing. As I said earlier, the issue of telecommunication is doing well in Tanzania. Mobile, yes, the issue of medicine and medical instrument also one of the industries which are doing good in Tanzania. Thank you.
Thank you very much. I couldn't agree with you more. We need policies. I believe the University of Dar es Salaam has an IP policy, maybe in Mzumbe, but the rest I'm not quite sure, of which I think there is a need for that, which will add value for us to even also have our own law that caters for collateral and using IP as an asset for banks to be able to allow people to get loans and whatnot. But I believe on the right track, probably perhaps we'll borrow from Kenya or Uganda. We have about 6 minutes. I know the panelists, you have already done your closings, but let me take at least 2 more questions and I'll restrict it to 1 minute each, please. I saw there's a question. This was from Justin. He was asking is there a commercialization of IP specific to East Africa compared to the rest of the regional groupings in Africa? If perhaps I don't know. Maybe Leila, you can touch on that. What's your take? Leila or Rosemary? 1 minute.
I think the reason there's a lot of crickets, you know, when there's not too much answers.
Yeah.
I think, yes, I think there is quite a bit of commercialization. A comparative analysis would need to be done. And maybe that is a good area of study in order for that to be discovered. Maybe it can even be a good thing to spur more, you know, more investment in the commercialization of IP. It would be good to look at what's happening, say, in South African markets, West African, Northern African, and the impact this has had on their businesses. Of course, as a market, you have very powerful brands. I think to the earlier question, in Kenya, the biggest winners are financial services providers and peripheral, like even telcos. I think those are the most valuable brands that are there currently in terms of valuation, with banking, of course, taking the lead and others in the telco industry. But I think it's important. That would be a good place to do a study on. Yes, there is commercialization, but I think what would move conversations forward if we actually got to crunch numbers and check what is the phase in East Africa. What does that look like? What does West Africa look like? Northern and maybe even Southern. I hope that answers it as much as is possible. So not really answering, but throwing it back to the audience. That would be a good place to study. Thanks, Justin.
Thank you. So last one, this is for anyone, even doctor, you can jump in. So there's someone, I think Gregoire, who was asking, there was an intention to harmonize IP laws in East Africa. So where are we in IP? I think he's referring to the IP protocol and after, but also he's saying cultural expressions are here, they are protected in the EAC zone. However, it's surprising to hear or find some common artistic performance of folklore, choration songs, such as songs, are protected in the names of individuals. So what about this? What is your take? When we have the EAC database for those kind of IP, just a reference when we're dealing with this challenge. So what's your take, Doctor? Anything, 1 minute, because we have only 3 minutes. And then I'll invite Catherine to close as well.
So the short answer is there's no East African IP policy. It's been in the works for some time, but it's not yet there. The same way there's no East African traditional knowledge or culture expressions policy, which has also been in the works for some time, and we hope we'll see it. Very technical and difficult to create. TK and TCs are not IP, but I call them quasi-IP because they're community owned and they have synergies because it's also creativity in a sense. Kenya has a TCE and TK policy, if I'm not, I believe it does, as well as Rwanda. Uganda is working on a TK and TCE policy, but hasn't yet come up with one in that regard. But these are all works in progress, as a short answer to that question. Yeah.
Brilliant. Thank you very much. So I would like to thank everyone who has been on this webinar today, the attendees, the participants. Thank you to the panelists for all your insights. I think we might need to do more, perhaps another one, because there is much to talk about, I believe. And I think we are headed in the right direction, especially on the laws, but the practicability of which, yes, is a challenge. With Uganda, we are far in terms of the lecture. We are putting our new laws into perspective. That is for Tanzania mainland, or in trademark terms, we call it Tanganyika. Zanzibar has its own IP laws, of which I would say they are pretty good, but they are progress in terms of making it practical, in sense of now being able to have a compound of laws that actually would be harmonized to cater for the Africa Free Trade Area and the office that is being established and after. But very good insights, very good observations. And as far as commercialization of IP, I think it's one of those things that we need to talk about, discuss, so that East African countries can take up on and see on how we can best have better laws that cater for that. And we have innovators, we have artists, we have all these creators within the ecosystem that are coming up with innovations, with inventions, with products, goods and services that would require their IP, because now you can have value and you can quantify it, and you'll be able to, let's say, go into a deal and negotiate and put your product or your IP for the product as a basis for negotiations, of which I think it's high time now that everything is opening up and we know that technology is taking over. And so I think it's one of the conditions that I think the East African community, East African society for this, and yes, the community for gearing towards developing policies, but hopefully one day soon we will have something that is tangible and that cuts across East Africa. So with that, I would like to thank you all for taking the time. Perhaps Catherine, if you have anything else to add on that, so that we close, I welcome you. And if there is anyone from East African Law Society that would like to say something, please, the floor is yours. Catherine, half a minute, and whoever from East Africa, please go ahead.
All right, thank you, Sunday. I think for me, as we draw this insightful session on commercialization of IP to a close, I'd like to express my gratitude to the esteemed panelists for sharing the invaluable expertise and practical insights. I think it's one thing that we can say is this webinar has been very illuminating. I think I want to say, I will speak for myself and also the other attendants, because of the illuminating conversations that have shed light on the multifaceted world of IP commercialization. And I think I would just like to thank the audience for the active participation, thoughtful questions, engaging discussions, and encourage everybody, all of us as legal practitioners or in our different legal fields, to continue exploring these ideas and collaborating with one another to just unlock the full potential of intellectual property. And on behalf of myself, ELS, and Sunday, I would just like to extend the appreciation to everybody and our esteemed panelists, and we look forward to hosting them again. And we look forward to also hosting everybody for the next session held by the IP committee. Thank you and have a wonderful day ahead.
Thank you all. That's a wrap for us. Anyone from East Africa Research, if you have something to say, if not,
yes, thank you so much. The moderator, Sunday, and the co-moderator, Catherine, who coincidentally serve as chair and vice chair of our Intellectual Property Committee. We would like to also extend a deep appreciation to our panelists who have been able to deliver quite well in this particular session. I was so excited to see the nature of questions and interactions going on in the chat room. It shows that a great job was done and members are quite interested in these sessions. So I think to you, my chair and vice, we should think about another theme within this area and have a further and more detailed conversation. But thank you so much. This was well delivered. To you, our esteemed participants, would like to say thank you for joining. Thank you for taking off 2 hours of your very busy schedules to interact and study and learn more about commercialization of IP. The IP cluster of the East Africa Law Society is here and is always looking forward to give you more interesting webinars that will that will grow your capacity in intellectual property practice within the region. From the Secretariat, we'll be issuing out certificates of attendance and certificates of appreciation to both our panelists and to you, our participants. So our IT team will be reaching out to each and every one of you on email. We'll also share a report of the session with you on email immediately after the session is concluded. I have just one announcement to make, and this is with regard to the 28th East Africa Law Society Annual Conference and Annual General Meeting 2023, which is slated to happen on the 22nd to 25th of November in Bujumbura, Burundi. Now come and join the biggest gathering of legal professionals within the region and probably the biggest within the continent this year. It's all going down in Burundi. If you want to get more information about the annual general meeting, please check on our website. You'll get all the information there. Register. We have good offer packages for you, our esteemed members. And also feel free to reach out to us at info@elosociety.org. From the Secretariat, we'd like to sign out and say, have a lovely evening, and we look forward to hosting you at more of our capacity building sessions. So over to you, Mr. Chair.
Thank you very much, Gabriel. Thank you everyone for taking the time. And I wish you all a very lovely evening. Thank you. Bye-bye.